Good evening. Captain Retired Matt Edwards here with the Facebook Live Observation Post Weekly Report, the 11th of August 2022. I'm going to try to keep this one fairly short because my eyes are feeling a bit tired and blurry. So, without further ado, the first issue I was going to talk about, I've got numbered 108 in my list, and it's the Retirement Income Security Benefit and High Income Replacement Benefit after 65. The Disabled Veterans' Right to Privacy. From 2006 to 2015, there was no need to provide Veterans Affairs Canada or the Department of National Defence with any financial information after age 65 because the supplementary retirement benefit was paid at age 65 and earnings loss benefit / service income support insurance plan ended at age 65. So my point is, under the Privacy Act, the government has the right to certain information when it wants to run programs. But after they finished the Pension Act pension in 2006, nobody else got it after 2006. Then they brought in systems that ended at age 65, which is very much like workers' compensation and long-term disability insurance. So there was no need for the government to have this information. Now that changed in 2015 because they brought in the Retirement Income Security Benefit after 2015 when people complained about the fact that there wouldn't be any money to pay the bills for disabled veterans after age 65. Now, they didn't just do the simple thing, which is what many veterans organizations said, is they should just extend the earnings loss benefit till you die. No, they brought in a reduced amount, 70% of whatever they were paying under the earnings loss benefit and SISIP. They made the Retirement Income Security Benefit 70% of that. So it ended up being 70% of 75% first, or 50.5%, or after 2016, the Retirement Income Security Benefit became 70% of 90%, or 63% of what you were getting before. Now, I keep thinking that we have to make people aware of how privacy is the main problem here. What I mean is that these people don't take actual money from veterans or other people. They take it into account to reduce their payment. They don't go to court, get a court order, and then divert a physical payment from one place to another place. What they do is use your personal information in a way that it wasn't intended to do, and then hurt you. They harm people by breaching your privacy. And my point about the after 65 thing, well, they should have done some kind of privacy impact study report to see, like, why do they need this information? Part of the reason I'm bringing this up is that the Old Age Security, which is another after 65 program, it has a reduced payment if you make too much money. If you have earnings when you're over 65 and you make too much, then they will reduce your old age security, which is not the way it's supposed to be. It was set up to be part of the Canada's retirement system. If it's going to be part of Canada's retirement system, then you cannot reduce it because you have other money. You just can't. It's part of the 3 pillars of our retirement. Old age security is the first one, Canada Pension Plan is the second one, and employment pensions and savings is the third pillar. So anyway, the thing is I think privacy is going to be their Achilles heel eventually. Moving on to point number 109, so I won't be here all night and keeping you here all night. Define non-indemnity and discuss. Now, an indemnity is a compensation for injury, or could be a compensation for time if you're getting paid for your service. So it makes up for something that you are owed. Now, a non-indemnity is when you take a prefix, non, and you reverse the regular word. So if an indemnity is a payment that compensates you, a non-indemnity payment is a payment that doesn't compensate you for a loss. Now, the first thing I said is account of the pension plan is non-indemnity. Why do I say that? Because it's been through the courts many times. 1998, Cugliari versus White, Ontario Court of Appeal. They said that the account of the pension plan disability was non-indemnity and contributory. 2002, the Sarbanes Supreme Court of Canada case. They said that the account of the pension plan disability is paid on the basis of an insurance claim and is non-indemnity and contributory. In 2006, there was the Nancy Wilson Saltz British Columbia Court of Appeal 2006 case, in which the judge used the account of the pension plan disability as being a non-indemnity payment and contributory, and then expanded it to the Great West Life long-term disability and the RCMP Superannuation Act pensions. By ruling that they were non-indemnity and contributory, that meant that damages were not allowed to take those things into account because they're apples and oranges. Point number B, the Canadian Forces Superannuation Act pension is also non-indemnity and contributory. How do we know? The Saltz British Columbia Court of Appeal case ruled that the RCMP pension was non-indemnity. So how can you say that the Canadian Forces pension or the public service pension is an indemnity for something? All pensions are you getting your money back from whoever's holding on to it in trust for you. SISIP, point number C. SISIP is also non-indemnity and contributory. How do we know? Nancy Wilson Saltz, British Columbia Court of Appeal, 2006, and a whole bunch of cases before that. You get insurance in relation to the premiums that you bought it with. You don't get it in relation to an injury. That's why it's non-indemnity. D. The Glynn Ontario Court of Appeal case in 1963 stated that non-indemnity can never be an indemnity. Now, they were talking about health and life insurance. So sometimes it's called accident and sickness insurance. Now we call it long-term disability, but it has a lot of names. When you get a payment from a long-term disability or a life insurance, it's a payment in contract based on the risk happening, and it has no indemnity at all, because how can you put the value on a human life? So it's put into the contract that you buy certain chunks of coverage. And they use tables, they use whatever, but basically you don't get indemnified. You get what you paid for. Okay, point number 110, and I'm going to make this my last one. I think I'm going to keep it short. At least I didn't cancel outright. Sun Life policy 12,500G and the Public Service Management Insurance Plan are set at 70% of the person's wages before they became disabled, while Great West Life and SISIP are 75%. Why is there this inequity? You would think that all of the federal government long-term disability plans would have the same rate, but there's a 5% difference between what I would consider to be the members type insurance, the RCMP, and the military members get 75%, and the disabled civilians get 70%. Now, don't get me wrong. I mean, I'm not saying that they should have more sense to keep things the same, and then nobody can bring up any problems with disparities. Because if they were both 70, no one would complain. If they were both 70, all 75, no one would complain. But they're setting themselves up for a fall when they have different long-term disability insurances with different rates payable to different groups. You're saying that one group is more deserving than another. Now, on that note, sort of an extra ad-lib, even though I was going to stop talking. Recently, I was going through my old phone, my gallery of pictures and stuff that's on Google, and I've been sending the pictures to my instant message, and I've downloaded them because whatever reason I saw them there, it reminded me of this or that. Now, one of the things that I found was a Hansard record, and the Hansard, as I will remind people, is a record of the parliamentary debates and stuff. And I didn't get a date, but the gist of the pictures was, why do we have different RCMP, Canadian Forces, and Public Service Superannuation Act pensions? They wanted to have all of them put together. But the fact of the matter is, a moth or a fruit fly or something, get away. Anyway, so they tried to say, even though they're similar, they can't be, put together. Now, the government acts as if these are all the same. That's not true. They aren't. They're authorized under a different law, different legislation. Instead of having one combined law act, you have 3 separate acts, and each act covers a different group of employees. I use the word employee, but that's one of my pet peeves. Soldiers and RCMP are members, not employees. But for my verbal slip, well, forgive me. The thing is that they have different laws. They could have made some omnibus law, but they didn't. So each one probably has its own administration. Each one is probably invested differently. They're basically the same. I will give them that. But it's similar legislation, not the same. Now, the thing is about all of this shit is the government seems to think, oh, I was bringing it up because of the long-term disability differences, right? So even though they're different, they're pretty similar. Now, that reminds me of another picture I'll mention before I go. See, that's what happens. I sometimes think I could talk forever if I don't watch it. I also saw a picture I had there about the group insurances and the public service healthcare plan. Now, my wife told me recently, because I got a glasses claim from a couple of years ago that I never sent in yet, and she said to me, that when we found a form, which I recently did, that they now have a different carrier for the public service healthcare plan. The thing is that plan is openly administrative services only. Now, that means it's just like the long-term disability plans, but out in the open. That the long-term disability plans, in this report, that the picture I found, they said that unlike the public service healthcare plan, the long-term disability plans are insured plans, which are, tendered off to insurance companies. Well, that's bullshit. Yes, they have companies that administer for the federal government, but they are actually, if you look at the legal terms, it's agent principal. So the principal is the Government of Canada, and the agent is, for the Department of National Defence, Manulife. For the Treasury Board Secretary people, it's Sun Life. For the RCMP, it's Great West Life. And for the non-unionized and managers and members of Parliament, it's Industrial Alliance. Now, the impact of that is that I have at one point I had 2 insurances. I had Manulife for my military service, and I had Sun Life for my civilian service. Manulife has cut me off since, and I'm trying to get it back. But my point is one of the key things that Sun Life and Manulife had with me is that Manulife said they wanted to talk to Sun Life, and I told them to fuck off over my dead body. However, they are really parties with the same agent principal. Okay, so you have Manulife is the agent to the Government of Canada. You have Sun Life, which is an agent to the Government of Canada. Now that makes them the same party. So they don't need my permission to legally talk to each other. All they need to do is talk to each other. But that would require them to admit that these are administrative services only policies, which the government flatly denied in the Dennis Manouche class action. However, the judge ruled against the government because basically he said Manulife is if anything, a stranger to the policy. Now that's a particular phrase that in contract law parties to the contract are the only ones that can sue or be sued. Anybody who is not party to the negotiation of a contract is a stranger to the contract. Strangers have no rights in a contract. See? So the judge never came out and said, I'm ruling on the administrative services only point that McKennis Cooper made on behalf of Dennis Mnuchin. But he did say it in other words. Okay? So even if the government tried to deny it, basically, I mean, another phrase that comes to mind is that the judge said, why would Manulife have any interest in taking a position contrary to its commercial partner? Think about that phrase, a commercial partner. So the government pays Manulife to do the administration of the SISIP policy. On paper, SISIP Financial Services is the one who hired Manulife, not the Prime Minister. Okay, so it's all parceled out. So you have, I'm going off the top of my head now, the Prime Minister, and then the Cabinet, and then the Minister of National Defense, and then the Chief of Defense Staff, and then it goes down to people underneath the Chief of Defense Staff. And one of those entities is a non-public property entity called the Canadian Forces Morale and Welfare Services. Now, and under the Canadian Forces Morale and Welfare Services, there is the Service Income Support Insurance Plan Financial Services. Now, one of the policies under the SISIP Financial Services is Policy 901-102, which is the one I'm always crapping on. But they have other policies, like life insurance policies, and I don't know if I can't tell you who it was, but one of the veterans I was talking to was told he was terminally ill with cancer. They encouraged him to get early paid while he was still alive, and then he could get the money and use it. Now, somewhere between the jigs and the reels, then they cut him off. They said that we're not paying you at all. After they told him to get an early payout instead of waiting until after he died and his family getting it. Now, he was given X number of months to live, but he was outlasting that. But that still shouldn't be held against him. That's crazy. You would think that the government, our insurance plan, would not do this to someone who's dying. It's reprehensible. I hope you would agree. Anyway, I'm going to call her quits on that note. That's about 20 minutes or so, but let me know later, or make a point in the comments. Do you like the shorter format? Because, I mean, I don't want to be talking all day. I hope that you don't want to be listening to me jabber around all day. Anyway, thanks for watching and have a good weekend.